Hello friends, how are you? Friends, in the present case at hand, I am going to discuss the departmental action in the Prevention of Corruption Act. Friends, the judgment has been pronounced by Hon'ble Jharkhand High Court in case of Rahul Kumar versus State of Jharkhand. In this case, a departmental proceeding has been initiated, increments had been withheld, and the concerned applicant submitted that I had been acquitted in the criminal case, but even though the benefit of departmental case seizing is not given to me. Entire proceeding of departmental is incidental and based on same fact on which the criminal action has been taken against me in Prevention of Corruption Act, but despite of having an acquittal, the concerned proceeding in nature of departmental proceeding has not been exonerated. He submitted that he joined the services in the year of 2007. He was not confirmed for a period of 14 years. He was caught red-handed in the meanwhile. The allegation of concerned state is of that I had demanded and accepted the bribe. PS Vigilance has registered the case. Ultimately, I got acquittal, and after acquittal, I submitted my judgment. But a second SCN has been issued, and in which I had given the reply, but they found the same not satisfactory, and a minor penalty has been imposed. Means my increment has been withheld. He submitted that as far as judgment of Honorable Supreme Court in Union of India versus B.V. Gopinath is concerned, it is submitted that during the pendency of a corruption case, departmental proceeding are required to be kept in the abeyance, and apart from that, as we know that Honorable Rajasthan High Court also specified the said view in judgment of Devendra versus Union of India, in which it is specified that during the continuance of the corruption case, the departmental action cannot be allowed to be continued. It is required to be kept in the abeyance. Okay, now, so it means the concerned court is giving the indication that the departmental action, if based on the same facts in which the concerned accused has been indulged in the criminal case, in that scenario, the benefit of acquittal should be given in departmental proceeding, means the benefit of exoneration. Friends, in this case, the proceeding is motivated as concerned applicant submitted before the court. He submitted that just to curtail my promotion, the proceedings are continued. He submitted that at my place, a junior has been promoted, which is a direct violation of Article 16 of Constitution of India. The argument of state on that point is that the acquittal by a criminal court cannot bar the departmental action. The state submitted that minor penalty imposed, and due to the imposition of the minor penalty as per rule number 14 of Jharkhand Government Servant Classification Control and Appeal Rules, the concerned employee cannot be given the benefit of promotion. But the counter argument of the concerned applicant is that as far as the said option is concerned, the opportunity of being heard is required to be given, which is not given to the concerned applicant, and apart from that, he got acquitted, and acquittal is honorable, and apart from that, the said rule cannot bar the remedy of promotion because imposition of minor penalty cannot curtail the benefit of promotion as observed by Honorable Supreme Court. He submitted that the charge sheet must be by the competent authorities. It is also the view laid down by the Honorable Supreme Court, and apart from that, opportunity of being heard must be given to me. He submitted the 4 cracking points which are required to be seen in the context of observation by the concerned court. The first point is that the charge sheet is not given by the competent authority. He submitted that the opportunity of examination must be given to him, and the same is part and parcel of natural justice as submitted by him in the light of judgment of Honorable Supreme Court Rup Singh versus PNB. Judgment is pronounced in the year of 2009, and apart from that, he submitted that the impact of acquittal in the criminal case is required to be considered. In light of Supreme Court judgment GM Tak versus State of Gujarat, and minor penalties cannot curtail the benefit of promotion, he also relied on judgment of Shiv Kumar versus Haryana State Electricity Board, Chandigarh. The court observed that in the present case at hand, the concerned authority failed to observe the principle of natural justice because the opportunity of being heard is not given to the concerned applicant, and apart from that, the document and evidence which is going to be submitted by the concerned agency is required to be proved. And apart from that, the concerned court, while relying on various judgment, observed that the function of adjudication is totally alien to the work of agent, because while doing the same, they are not supposed to be an agent of government, because the court in this case also determine the liability of the concerned adjudicating authority or inquiry officer who are involved in conducting such departmental action. The court specified that the concerned applicant is to be provided with an opportunity to examine the witnesses, and apart from that, he is to be given the opportunity to sustain that he is not a guilt. If such opportunity is not given, in that scenario, we are going to infringe Article 311 of Constitution of India. The said exercise of right cannot be casual, and apart from that, we have to bear in mind that we are totally bound by rule of law, and right to get a natural justice is part and parcel of rule of law. So in that case, looking into the facts and circumstances, the court had set aside the order and remanded back the case for the purpose of proper inquiry. So the said judgment inter alia enlighten the 5 important points which are to be borne in mind while contesting a departmental action during the pendency of a case under Prevention of Corruption Act. Number 1, first identify that whether both the cases are identical, means are based on same facts or not. Once you get the acquittal in a criminal case, definitely you could have the benefit in the departmental action if initiated on same cause of action. Number 2, refusal of sanction by the sanctioning authority is also a key factor, because if the concerned sanctioning authority is going to refuse sanction and department is still initiating the action, in that scenario you may point out the perjury and make the objection accordingly. Number 3, usually the state take the point that it is not an honorable acquittal. The honorable acquittal can be considered. There is a difference between acquittal by having a reasonable doubt and acquittal by honorable acquittal. The key point is that in honorable acquittal, the concerned witness are not supposed to be hostile by the concerned accused. He has to examine, has to testify, has to contradict and to have the benefit. So in that scenario, when you are having the honorable acquittal, you could get the benefit. But this point is also wrong, because acquittal is acquittal, even though it is beyond the reasonable doubt or it is honorable. Once you got acquitted, you could have the benefit, submit your claim accordingly. Number 4, the imposition of minor penalty cannot curtail the benefit of promotion. And last one is that submit the proper submissions. If they are not going to provide you opportunity of being heard, they are not going to provide you opportunity of submitting your stand. In that scenario, Article 311 of Constitution of India may be violated, and you could make objection by the way of writ before the concerned High Court for vindication of your grievances. So remember this point. And last point is that during the continuance of the Prevention of Corruption Act case, the departmental action cannot be continued. It is required to be kept in abeyance as observed by Honorable Supreme Court and Rajasthan High Court. So these are the important guidelines and important point for your help. So don't worry, just fight your case and definitely we will win. So friends, see you in the next video. Till then, Jai Hind, Jai Bharat.